Please take your seats. Please take your seats.
Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Barbados. Hearing of application in CCJ Appeal BBCV number 4 of 2019 between Russell Crumpler and the Financial Services Commission, CLICO International Life Insurance Limited, and the Barbados Investors and Policyholders Alliance Incorporated. Today's panel comprised Mr. Justice Anderson, Mr. Justice Barrow, and Mr. Justice Burgess. Please state your appearances for the court.
May it please you, Your Honors, in this application, I appear for the applicant, and with me is Ms. Wendy Murad.
May it please you, Your Honor, Sheena Ann in of Clark Gittins Farmer, led by Learned Senior Counsel Mr. Ramon Ali on behalf of the second respondent, CLICO International Life Insurance Limited.
Yes. Thank you, Counsel, and good morning. I believe we are going to hear first from Mr. Philip Macquart. We're going to present the application. May I suggest that if it's more convenient to you, that you could sit. We're not going to ask you to stand. Now, as I understand it, this is an application to us for special leave to appeal a decision of the Barbados Court of Appeal, which refused special leave to allow an appeal to it. Yes?
Correct, Your Honor.
Okay, so this morning we're simply going to hear that application. We're not going to consider anything further. Obviously, it's a procedural point only. And I know that in the order which went out earlier, we had indicated the possibility of 1 hour for each side. But given the nature of what we're considering this morning, a purely procedural issue as to whether the Court of Appeal was wrong to refuse leave, I would want to suggest that we could be much more concise with our time. In light of that, Mr. Macquart, how much time do you think you would require?
Grateful to your Lordship. I had always intended to be well under the hour, especially in light of the court's ruling concerning the fresh evidence point. Yes. It has taken a lot of the arguments out of the equation at this point. At this point, I would suggest maybe 25 minutes at the most, 20, 25.
Yes. Okay. Yes, that's fine. 25 minutes at the most, as you said. You don't have to use all 25 minutes, of course, but 25 max. We're willing to hear you, sir. Please.
Grateful, my Lord. Your Honor, sorry.
And before you start, my brother just reminded me I should say that the same, of course, applies to Mr. Aline, who might be even more judicious in the time that he has allotted. Okay, Mr. Macquart.
You have read me well, my Lord.
Thank you.
Your Honors, the application before you today is for special leave to appeal made pursuant to Section 8 of the Caribbean Court of Justice Act and Part 1012 of the Caribbean Court of Justice Appellate Jurisdiction Rules of 2019. By way of some background, I hope the court will indulge me in setting out very briefly what is the history of this application. The applicant is a judicial manager appointed for the Montserrat branch of the second respondent, and as such had similar duties to the local judicial manager here in Barbados, Deloitte, who presently acts through Mr. Toppin. However, what places the applicant in a unique position from the rest of the branches within the region is that the Montserrat territory holds no physical assets of the second respondent within its jurisdiction. So the only asset they have would have been the premiums paid into the bank account held in the Bank of Montserrat. Therefore, while branches in territories like St. Lucia and St. Kitts have taken steps to bring fence the physical real estate assets of the second respondent and safeguard them exclusively for the benefit of the policyholders within their territories, the judicial manager of Montserrat is unable to do so. The applicant is completely reliant on the judicial manager in Barbados to carry out its duty fairly and in a manner that is transparent so that the applicant can carry out its functions and advise its supervising court of what is going on in the proceedings and whether it's in the best interest of the policyholders of Montserrat. In this regard, Your Honours, the applicant views it as critical that he be given access to information in a timely manner and that he be kept abreast of any developments which should arise in the course of the judicial management proceedings. And ultimately, it is in this respect that the applicant has had great difficulties in achieving this goal as a result of the actions of the Barbados judicial manager. Throughout the applicant's tenure as the appointed judicial manager...
Mr. McQuart, I think you can take it that we are familiar with the complaints that your client has. I think our concern here is whether the Court of Appeal was right to refuse leave or was wrong to refuse leave. So could we focus on that precise point, please?
Yes, grateful. Well, in that case, Your Honours, I will pass on to the present application. The law in this regard is not in dispute, Your Honours. The test for the granting of special leave has been well settled and restated recently by Your Honours in the case of Ramsahoy, which has made it clear that the applicant must show a reasonable prospect of success in his proposed appeal, or alternatively, identify any egregious errors of law or miscarriages of justice in the decisions of the courts below. In this regard, what the applicant complains of is that the application before the court of first instance was simply for disclosure and for the ability to join in the proceedings or have some kind of representations in the proceedings involving the petition. These were the two orders sought. The court, in coming to its decision, the first instance court, if I can take you to paragraph 45 of the decision of the lower court, and that is at page 65 of the record, Your Honour.
What I have always found helpful, counsel, is to instead focus on what the Court of Appeal said in reviewing what the High Court said. Because the Court of Appeal passed upon what the High Court did. So I suggest you go to the Court of Appeal's decision on that matter.
Yes, I take your point, but I was planning to take the court to both of them, both instances where I submit that an error of law had occurred.
And the question is very simply, did the Court of Appeal make an error of law? If it was led to that error by the High Court, you don't need to concern yourself for present purposes whether that is so. The question is, did the Court of Appeal make an error of law? So show us where that error lies.
Grateful, Your Honours. If I can take you to page 31 of the record, which is paragraph 54 and 55 of the Court of Appeal decision.
Yes.
Paragraph 54. The intended appellant asserted at paragraph 21 of his affidavit of 21st of November 2017 that he needs information to independently verify the fair and equitable distribution of the assets and properly assess whether the proposed distribution under the Barbados restructuring plan is in the best interest of those policyholders, and that if he is unable to join in these proceedings and obtain the disclosure that I seek, there is a real risk that the assets being dissipated and are transferred without being subject to any kind of review from me as the judicial manager of Montserrat. There is a real risk that this will have an irreversible detriment on the impact of the interest of the Montserrat policyholders. The court continues, by these assertions, the intended appellant is in effect seeking to challenge the plan which was approved by Justice Chandler. To our minds, such a challenge could not be addressed by way of joinder, but ought properly to be addressed either by way of appealing the order or by bringing of proceedings against the judicial manager. Now, Your Honors, what is clear is that the court has gone beyond the scope of the application that was before it. In the quarter of first instance, the application was for leave to join and for disclosure of certain information. The applicant is unsure why the court needed to go into the affidavit and ascribe certain motives to the applicant in this regard. What the applicant wishes to do with the application is ultimately a matter for the applicant. There are other options available to it. It may well have joined in with the appeal launched by the ECCU and assisted the ECCU in the course of its appeal before the Court of Appeal. It may very well have, depending on what information was revealed, made an original application to this court in its original jurisdiction. All of these are possibilities. And it is uncertain why the court ultimately went to the conclusion that the application was in aid of undermining the order of December 22nd, 2015.
Mr. Marquardt, I don't think that a fair reading of paragraph 54 lends itself to that interpretation. I think that what the court was saying is that the effect of granting the joinder application would be this. It wasn't, on my reading of 54, intending to ascribe any motive or intention of any sort to the applicant. Of course, I stand ready and willing to be shown how you arrive at the position that motive was being rather than effect.
Well,
but sorry, sorry, Mr. Marquardt, before you answer that, let me add to what my brother said. I'm looking at your grounds of application at page 3 of your grounds that you filed to us, and item 3 on page 3. Your ground of application says that the Court of Appeal wrongly interpreted the intended appellant's application to intervene, etc., because he was seeking to merely ensure that the said plan is being implemented fairly to all the policyholders. So the motive of your applicant was to get into the High Court proceedings for him to ensure that that plan was being implemented fairly to all the policyholders. I don't know how different this is from the substance of what the Court of Appeal said in the passage you quoted.
Well, I'll try my best to explain, Your Honor.
Okay.
The first sentence in paragraph 55 reads, by these assertions, the intended appellant is in effect seeking to challenge the plan which was approved by Justice Chandler.
Right.
there was nothing in the application that sought to challenge the plan approved by Justice Chandler.
You're seeking to challenge the implementation of the plan.
No.
But that's what...
We are seeking to make sure that the plan is being implemented fairly. What we complained of was that certain disclosures which we sought and asked for were refused to us, but were granted to the Barbados policyholders as a result of their being members, as a result of them having membership on the board of CLICO and Res Life. It granted them access to certain valuation reports in respect of property which had been specifically denied to the policyholders of Montserrat and the applicant herein.
Right.
That is why we made the application for disclosure.
So you want really to ensure that things are being done properly?
Equally, in accordance with natural justice.
No.
Yes,
hold on. Whatever is the basis for your requirement, you want to ensure it is being done properly.
Correct.
Mr. Marquardt, what troubled me was whether your client was not seeking really to control these proceedings by the learned High Court judge and his judicial manager. It quite frankly troubled me.
Well, I don't know, my lord. I have to confess I was more troubled by the fact that certain policyholders were getting information and others were being denied that information.
Mr. Marquardt, I think that, Mr. Walk, if I may, please, I think at the beginning the President pointed to the fact that we are dealing with certain procedural issues. And basically, it comes down, first of all, on the question of joinder. It comes down to whether the Court of Appeal was correct in finding that Justice Chandler had properly exercised his discretion in relation, which is given to him under CPR 19.3. What you're doing is not really assisting, I think, me, with respect, is not assisting in understanding whether the discretion was properly exercised, which is basically what I think that the hurdle that you have to overcome. You have to show that this court should find that the discretion was blatantly wrongly exercised or patently wrongly exercised. But so far you're not helping us in that regard. Just a footnote as well. The applicant is the judicial manager appointed by the court in Montserrat. Am I right?
Correct.
And he is under the control, like the judicial manager in Barbados is under the control of the High Court here in Barbados. He is under the control of the court in Montserrat. Is he making this application pursuant to an order of the court in Montserrat? I didn't want to raise that question earlier, but and you can ignore it, but stay with the CPR 19.3 and shows how the court wrongly applied the law. How the court applied the wrong law, and secondly, how it applied the law wrongly to the facts which were before it.
All right. I will address the court on that, Your Honor. The only point that I was making, which I think is relevant to the application, was that the court, in dismissing the application, seemed to draw the conclusion that the applicant was launching a challenge to the plan approved by Justice Chandler, and insofar as that has been put forward as one of the reasons for dismissing the application, we say it is wrong and it is not supported by the evidence, that the court has to deal with the application before it only, and that application sought orders for disclosure and for joinder. None of those applications seek to set aside the order of December 22nd, 2015. I will pass on now to the CPR point, Your Honor. No. Yeah. Your Honor, the application for joinder was phrased firstly on Part 19.2.3 of the CPR, which sets out the test for granting leave to be joined as a party to the proceeding. That provision has been interpreted by Your Honor Justice Burgess in the Financial Services Commission and BIPA case decided on the 31st of October 2012. In that case, Your Lordship held that, but with all due respect, paragraph 15, Justice of Appeal Williams was in that case stating the test based then on the applicable rules for adding a party in RFC Order 15, Rule 6, 2B1 and 2. Those rules have been revoked by Part 73 of the CPR and replaced by Part 19.3.3 of the CPR. In fact, BIPA's application before Justice Beckles was made pursuant to Part 19.2.3, and this provides that the court may add a new party to the proceedings where A, it is desirable to add the new party so that the court can resolve all matters in dispute in the proceedings, or B, there is an issue involving the new party which is connected to the matters in dispute in the proceedings, and it is desirable to add the new party so that the court can resolve that issue. His Lordship continued, thus a critical element of the test set down in Part 19.2.3 is that there must be shown to be matters in dispute before a party can be joined under that part. And with due respect to the submission by BIPA that the policyholders were previously disadvantaged by the failure of the Office of the Supervisor of Insurance to properly exercise its duty under the law cannot amount to matters in dispute in judicial management proceedings. Now, first of all, Your Honors, I take the point that counsel for the respondent has made over and over, that judicial management proceedings are extraordinary proceedings, and I agree with that. And as such, I think the court has to be careful when applying rules like this generally to a specific type of proceedings, such as judicial management. Because in judicial management, the court is there concerned in working out the best scheme of arrangement to keep the insolvent company from being dissolved and giving the best benefit to the policyholders. So there will not be a traditional dispute in terms of what normally takes place in the adversarial process between a claimant and a defendant. In this circumstances, we say the dispute arose on account of the fact that, one, we had not been provided with the disclosure sought, which had been provided to other people. Two, that the disclosure that did come in the form of the 2017 report provided some accounts which were discordant with the accounts held by the applicant in terms of what was applicable to Montserrat, in terms of the fact that Montserrat JM has held that he has, before his appointment, money was paid directly to the branch, to the Barbados branch, which was denied by Mr Toppin in his affidavit. We said that there was an admission coming from the head of CLICO Holdings Barbados that there was an amount in excess of $45 million due to the Montserrat branch, and none of that was reflected in the accounts which were published in the 2017 report. What was said was that there was assets to the amount of around 45,000 Barbados, and that the liabilities were far in excess of $36 million, which in the ordinary course of things seems to be impossible, because a company with 45.
Mr. McCourt, thanks for that. So, would you agree with me that the Court of Appeal identified the test that ought to be applied in relation to joinder?
Correct, yes.
Would you agree with me as well that the factors that you just mentioned were considered by the Court of Appeal in deciding whether to grant leave?
Yes, Your Honor.
Okay. So, in renewing that before us now, you're seeking to have this court substitute its own decision, judgment, discretion for that of the Court of Appeal?
In a way, yes. We do say that the court was wrong to disregard or didn't give sufficient weight to these matters.
Yes. But it seems to me that our touchstone must be whether the Court of Appeal not only was wrong, but was blatantly wrong in the exercise of their jurisdiction. Because if we don't take that as our test, then we are simply going to be a second Court of Appeal giving a different decision on the same matters considered already by the first Court of Appeal. It can't be that we are going to do the same thing as the Court of Appeal in Barbados. It has to be that we consider whether the Court of Appeal there was so egregiously wrong in the exercise of its jurisdiction that it warrants our interference. So I'm not, if the Court of Appeal considered all of the arguments that you just mentioned and applied those arguments to the correct test. Yes, go ahead.
No, I don't think they considered the fact that the Barbados policyholders were granted access to these documents but were denied.
Did you raise that? Did you raise that with them?
That was before them on the evidence, but I accept I did not raise it squarely before them, Your Honor.
So the matters that you raised before the Court of Appeal were duly considered by the Court of Appeal. Court of Appeal applied the correct test, and you don't like the result that they came to. I mean, that's basically, I think, what you're arguing. Am I wrong?
Your Honor, we're arguing that the Court of Appeal, yes, did not give sufficient weight to the factors we set forward.
Yes, okay.
So that's a matter of the exercise of a discretion, as the chairman is indicating. How much weight to have given to certain factors?
Yes, Your Honor.
I don't think we are saying that the issues that you're raising are not interesting. They seem to be very interesting from my point of view. It's just that the way in which you're trying to get them ventilated in the system is a little bit problematic. And there are other ways, of course, I gather, of having those issues ventilated. For example, I gather that there is an appeal against the order of Justice Chandler, which is now before the Court of Appeal. I imagine that if you wish and thought it appropriate, you could, in fact, make a fresh application before the judge, supported by the fresh evidence that you say that you have. But for us to override the discretion exercised by the Court of Appeal, not to grant leave, I think we might require a little bit more than you're giving us.
I accept that, Your Honor. And to be honest with you, I was hoping to be able to rely on some of that fresh evidence. And I accept that the court had the jurisdiction and was able to make the order it did in dismissing that application. But just by way of background, it wasn't my intention to rely solely on those matters in this appeal, in this application.
Got you. Okay. Can we stop there, or is there anything else pressing that you have to say to us on this?
No, Your Honors, no, I think I will, unless the court wishes to hear me on any further matter, I will give way to my friend.
Wonderful. Thank you, Mr. McWatt. Thank you much, Mr. McWatt. Mr. Aline?
Yes, my lord.
You're in the very interesting position that I'm not sure that we need to hear from you unless you particularly want to press anything on us. Do you?
No, my lord, I actually haven't heard the exchange, was about to say that I would rest on my submission. I would not bother you any further.
Your submissions to us is never categorized as a bother. I can assure you of that. So thank you for your, thank you. Yes?
Yeah.
Thank you.
No, I was just saying that I need not make any comment. I would rest as where we stand.
Wonderful. Thank you. Thank you both for your appearance and your contributions. We will. All right, so gentlemen and ladies, sorry. After a brief consultation, we have decided to dismiss this application. There will be a very, very brief judgment to follow, but the substance of our decision is that we cannot accede to the request for special leave. Is there any consequential order anybody wishes to urge upon us? Mr. Aline?
Yes, my lord. We are dealing with two entities and two persons who are obviously pressed as it comes to their financial circumstances. But to the extent that they are both in the same position, I believe an order as a cost would be favorable in the context of following the course of the judgment.
Mm-hmm. An interesting dimension, Mr. Aline, because the question as to what are the costs which may be recovered on a special leave application which is not treated as the hearing of the appeal, is this something that you have had a look at, Counsel?
I have not, my lord. I must admit, I did not expect to be at this stage presently, and I have not looked at that issue.
I should indicate to you that what has engaged me is part, I think it's 1833 of the rules.
Yes, my lord.
And that says, where a special leave application is treated as the hearing of the appeal, which is not the case here, the costs of an occasion by such appeal shall be within the discretion of the court, but no higher than 2 times the quantum of basic costs for appearance in court on an application for special leave to appeal, as is set out in the Schedule 2 of these rules. And Schedule 2 essentially says that for appearance in court on application for special leave to appeal, it is 4,000 Barbados dollars.
The maximum would be what, 8?
Well, if we had heard the
If we had heard the
it is confined
to what? The 4?
to 4. It is a matter,
I believe
Counsel,
your reading is...
it's a matter, I do not want to spring this on you. Perhaps you can discuss it with Mr. McWatt, because such a determination, I think, would have far-reaching implications. We have not heard this argued. We have not heard this particular matter argued. I do not want to suggest that we are deciding, without having heard full argument, that all special leave applications can only fetch $4,000, which may be the case. If that is the case, it would alter, to my mind, the conduct of all future special leave applications where, before counsel thought they could get $80,000, to be told now that all special leave applications are confined to $4,000, would be quite a step. So perhaps it is something that you may want to, I don't know, make submissions on, or you might just want to agree costs now so that it is not a binding decision.
My lord, I take your point that it is not a matter that has been dealt with by the court. And in these circumstances, I think it may be helpful if we were to submit on the issue so that any decision of the court would be an informed one that is reflecting on the matter.
Alternatively, you can agree costs and leave this to be decided, I think, at
another
a
time.
full oral hearing. So we will say, would it be agreeable for us to say costs to the respondent to be agreed or taxed and leave it for you all to agree?
As your lordship pleases, that would be acceptable. I'm willing to agree to that order, Your Honor. I'm willing to sit down with my friend and see if we can come to some agreement and in respect of costs. I don't think that the application was that lengthy, but obviously there would have been other things to take into account, and I'm happy with the order, Your Honor.
Mr. Aline, you remember that,
Sir.
sorry, you remember that in matters like these, I used to think that one has to be magnanimous in these matters. And is this really a case that you would insist on costs?
Well, my lord, I at this point I speak on behalf of my client. We are somewhat agreed with these proceedings having been taken this far. And as I said, both entities are in no better state than the other. They have identified their options in relation to Court of Appeal with the ECCU. I believe my client is somewhat disturbed that we have actually had to invest this amount of time and effort on this point and to this level. And that would be the only reason why, as you know, my lord, I am one to always give and give way in certain circumstances. But those are the factors that are influencing us in this matter.
Understood.
Your Honor, I will say one thing about that, and that is that both the High Court and the Court of Appeal did not make any order as respect to costs in these proceedings. And I understand that notwithstanding the same, the applicant still continued to pursue his appeal. But I think that there's a reason why the courts deferred the issue of costs in this regard. And I think there is some merit to the point raised by Your Honor, Justice Burgess.
Well, thank you. We have heard you. I think what we'll do is to reserve the order as to costs, and that order will appear in the very brief judgment, which will be forthcoming in short order.
If you agree before the judgment comes out on costs, then let the registrar know.
Thank you all very much.
Thank you, my lord. All the best for the season.
And you.